Workshop. Thank you, everyone. Give me 1 second. That off the screen. So welcome and thanks to everyone. I know we have for attending today's workshop. We have quite a few folks taking advantage of our virtual option, which is great. We have some in-person attendees here as well. The topic of today's NACO workshop is the Nevada Open Meeting Law and some principles of good governance. The goal of the workshop is to provide an overview of recent reforms to the open meeting law and guidance on how counties can utilize best practices for good governance. I first want to start off by thanking Jennifer Bethune, NACO's government affairs manager. She did a great job, I think, putting this, coming up with the idea really and executing on this workshop. She is joining us virtually. She's done a great job on this workshop, so I want to take a moment to thank her. For those of you who don't know, my name is Vincent Guthrow. I serve as the executive director at the Nevada Association of Counties, or NACO. And NACO, I did want to make a point about this. NACO and other stakeholders have been heavily involved in the Open Meeting Law Task Force that was convened by the Attorney General's office. I think overall they've been great partners, sort of balancing those different needs of transparency and openness in government with the ability for local governments to comply with the law and conduct their business. So before we get into the presentations and then the question and answer period, I wanted to take a few minutes to introduce our panel and highlight some of the information that they'll be sharing with us all today. Let's see. First with us is Rosalie Bordelov. She will give us an overview of recent updates to the Nevada Open Meeting Law. Rosalie is the Chief Deputy Attorney General over the Boards and Open Government Division at the Nevada Attorney General's Office. Her division houses the Open Meeting Law Enforcement Unit that investigates and issues opinions regarding complaints alleging violations of the Open Meeting Law that are filed with the Attorney General's Office. Also with us today is Wayne Carlson. He's the Executive Director of PoolPact. Wayne is president and sole owner of the Public Agency Risk Management Services, which is a risk pool administration and risk management consulting firm, specializes in services to public entities. This was created back in 1985 and under a bill co-sponsored by the Nevada Association of Counties and the Nevada League of Cities. Wayne authored and lobbied for passage of pooling legislation, and the legislation enabled a property and casualty pool called the Nevada Public Agency Insurance Pool, or the pool. Wayne has served as executive director of the pool since its inception. These two pools have 140 member counties, cities, school districts, hospitals, towns, and special districts throughout Nevada, primarily in the suburban and rural counties. Finally, with us here in Carson City, we're pleased to have Dan Yu, who's an assistant district attorney in Carson City. Dan has been with the Carson City District Attorney's Office since 2016. He currently serves as the Assistant District Attorney and Chief of Staff for the office. He supervises the civil division and oversees all civil matters for the city. He has served as a counsel to various boards, committees, and commissions of the city, including the Board of Supervisors. Prior to his work with Carson City, he served as a legislative attorney with the Legislative Council Bureau for nearly a decade. During which time he was committee counsel for committees in both the Assembly and the Senate, including standing committees on commerce, labor, and energy. So I want to thank all of our members of our panels here today. And before we get our program, just a couple of housekeeping items. Since most of you are participating virtually, just make sure you're muted if you're not talking. It'll help with background noise so that we can have an efficient presentations. We will take questions at the end of the presentations. The way we're structuring our program today, we probably have about 15 to 20 minutes set aside for this. So go ahead and hold all your questions until the end, and we can engage. We're a little informal here at NACO sometimes, so happy to have an informal roundtable discussion about anything that comes to mind when you hear the presentations. Let's see. And finally, this workshop is being recorded. We'll post a link to it on the NACO website. So if there's someone from your county who wasn't interested in attending today but was unable to attend, please let them know that these resources are available on our website, nvnaco.org. So with that, I don't want to belabor this any longer. I'll turn it over to Rosalie Bordelov first. So if you want to unmute, if you have a presentation to share, Rosalie, feel free to share that yourself through Zoom, and we'll go from there. Thanks again.
Good morning, everyone. I do. So let me see if I can first get this presenting so I can share it.
Got it.
I have a short bit. Let's see, slideshow. Me. Okay.
There we go.
There we go. Are you guys able to see everything there?
Yeah.
Perfect. So I'm going to give a brief bit of an overview of the OML, and I don't have a lot of time, so I'll probably go through all of this real quick and get into 2023 updates, but happy to answer any questions towards the end. And I also have a 1-hour version of this training that goes into a lot more depth. That should have the PowerPoint itself, the full PowerPoint is up on our website right now. And as soon as our IT can get everything cut and up there, we should have videos of a training session we did in October that's a full hour on OML. For anybody that's interested, it'll be available on the Attorney General's website. So to give a bit of start on the overview, first of all, Nevada's open meeting law, which is housed in NRS Chapter 241, is the general intent of the law is that public bodies exist to aid in the conduct of the people's business. And the intent of the law is that actions be taken openly, deliberations be conducted openly. This stated intent guides our interpretation at the Attorney General's office on OML complaints. It also guides interpretations by the courts. And so I always emphasize really thinking about that when you think of any public comment restrictions, any way you're interpreting this law, really think about that intent and that purpose. So the OML applies to public bodies, and I won't get a lot into the public body definition because I think most of you know when you are, and most of you are dealing with public bodies with your county commissions and various bodies within your counties. But even if you have a public body, the OML only applies to a meeting, which means a quorum together with deliberation or action. A quorum is a simple majority of the total body or another proportion established by law. There was a change in 2023 to the quorum definition, though it only applies to bodies that are not entirely elected. So to the extent that your body is comprised entirely of elected officials, the quorum is still a simple majority or another proportion if that's in your laws somewhere, but it's usually the simple majority. For those that are appointed or at least have members that are appointed, vacancies no longer count towards the quorum requirement. This change was largely put in there to target a lot of smaller bodies that are entirely appointed, often by the governor, and there are insufficient applicants that they frequently have large amounts of vacancies. But keep that in mind to the extent that you may have a smaller subcommittee or some other body that has appointed members. And in making your quorum calculation, there was a change. Deliberation means collectively to examine, weigh, and reflect upon the reasons for or against an action. That's the one that can be more difficult. Action is a vote for elected bodies. That's all members, whether or not they're present. For non-elected bodies, it's a majority vote of the members present. Deliberation is the one where people can walk into mistaken violations at times when you have a group of a quorum together that deliberate. The main exception to that is the attorney-client conference, and that's on potential or existing litigation. There was a change this session in the law with respect to how the meeting definition is written, and that's an AB 52, which did come out of the OML task force that was mentioned earlier. The changes to the meeting definition don't change the actual definition. So to the extent that you've been applying it, your application should still be the same. We tried to clean up the language so it was a little bit clearer, especially to non-attorneys, that you have to have that deliberation or action. So you can have a quorum together at a social function, at a ribbon cutting, there are many functions where you might have a quorum of your public body present. So long as they don't engage in deliberation regarding a matter within their jurisdiction and control, then you don't have a meeting. And we clean up the language so it's really clear that that's what's required. And the only true exception to that is the attorney-client conference. And that is to protect the attorney-client privilege regarding potential or existing litigation. To the extent your counties are local government employers under NRS Chapter 288, that's a separate exception. It's not to the definition of a meeting. That is an exception to the chapter as a whole. The exception there is if you're meeting with your management representative regarding negotiations and collective bargaining agreements. And you can always seek your counsel's advice as to which of those meetings, but you've probably had some of those closed. Those are a complete exception to the chapter, but it exists outside of 241. And so I'll kind of note that there may be some other exceptions, especially with school districts, that exist in other NRS chapters. If you're ever unsure, you can seek advice of counsel, and your counsel can let you know if they are gathering you together in private because of a specific other exception. When it comes to complying with the OML, I won't get into the agenda requirements. Staff's aware of a lot of those. They're listed on here. They can be found in 241.020. The changes this year with respect to the agenda requirements were the location of the meeting was added back in AB 219 as a possible place for posting. But there needs to be at least one physical posting location for the agenda. It can be the office of the public body or the location of the meeting if there's a physical meeting. It used to be 3 separate prominent locations. That was changed in 2021. The online posting is absolutely necessary. That is to your own website if you maintain one, and Nevada's notice website. And as always, that posting, hard deadline of 9 a.m. the 3rd working day before the meeting, as well as notice sent to persons who've requested. And there are a lot of other nitpicky requirements of what needs to be in that agenda, and a lot of staff is usually aware of those. Happy to get into those in other times. I usually get, when I do this training for I do it for clerks training sometimes, and we get a lot into those then. A lot of other requirements go with open meetings to make sure you're in compliance. That includes reasonable efforts to assist and accommodate persons with physical disabilities desiring to attend the meeting. Additional notice is required for the consideration of a person's character, misconduct or competence, or to take administrative action against a person. There were changes, and I have a slide kind of at the end where I gather together all those 2023 changes. There were changes to the timelines when it comes to notice for character or administrative action. The old timelines were longer. The new timelines are a little bit shorter, including a couple of other options. So if you're still complying with the old notice requirements, you'll still be in compliance. But the new ones offer a little bit more flexibility. As you're probably familiar, meetings must be recorded or transcribed. Minutes need to be kept and approved within 45 days or the next meeting of the public body, whichever occurs later. And supporting material is required to be available to the public at the time it's provided to members of the public body. I will note, even though this wasn't a change in 2023, our kind of understanding and application of it has interpretations have come since the 2021 change. Or I guess that was 2019, I think the supporting material definition was added. Then in 2021, we added the ability for entirely virtual meetings. While that ability only applies to bodies that are not entirely elected, if you are holding an entirely virtual meeting, you have a requirement to post the supporting material to your website at the time that it is provided to a quorum of members of the public body, or when the agenda is posted, whichever comes later. And it's not explicitly stated that way in the law, but because of the new supporting material definition, I say new, but it's 2019, we've had it for about 4 years. The supporting material doesn't meet the definition of supporting material until it relates to an item on a posted agenda. So if it's something that's been given to a quorum of members of the body, or you've given that packet ahead of time, as soon as that agenda is posted, that material needs to be up on your website if it's the entirely virtual meeting. If it's not, there's a separate requirement, and I don't have it exactly in front of me because I don't represent a whole lot of elected bodies, but there is an online posting requirement for elected bodies in counties or cities where the population is greater than 45,000 people. So just keep that in mind, and for staff to double check that requirement or run it by council so that your procedures are in compliance. For public comment, because this is one of the most common areas for us to get complaints. The law is changed with respect to how public comments described. AB 219 changed that in 2023. However, it did not change the actual requirements for format of public comment, with one exception. Public comment, to meet the minimum requirements, you can either have a general or a general period at the beginning and do the 2-period option, where the first one is either completely general or limited to items on the agenda, and that's heard prior to any action items. Or instead of that general, that period at the beginning, you can have public comment on each action item after discussion of the item, but before the vote. In addition, there needs to be a second general public comment period at some point prior to adjournment, where public can comment on items not on the agenda, but within the jurisdiction and control of the public body. I often recommend the 2-period option as a minimum because it covers that minimum requirement. It's not hard to do. It's perfectly fine to limit that first period to action items. And then if you have a particular item that you know is going to gain a lot of public comment or something else, you can take additional periods later, and there is no harm in that. That was one of the changes to the law in 2023. It even now specifically says there is no harm in taking additional public comment periods. The note I'll change the exception, I guess, to the requirements also that was changed in AB 219 is if you have a multi-day meeting where the agenda specifically says the body's going to meet starting on one day, continuing to another. In the past, we interpreted the law to say where it was a continuing meeting and it was agendized as such for multiple days, that it was one whole meeting. So it didn't necessarily require 2 public comment periods on each day of the meeting. AB 219 has changed that requirement. If it's a multi-day meeting, you must have 2 public comment periods on each day. Generally, restrictions on public comment must be reasonable time, place, and manner restrictions. That's the most important. Even if your public comment policy is completely time, place, and manner neutral, the application of the policy needs to be that way as well. And usually if somebody's abusing your public comment and refusing to listen to the restrictions, your only recourse is to remove the person, but it's specifically allowed if they are disrupting the meeting to the extent that its orderly conduct is made impractical. And the one other change I would say for 2023, this only applies, well, actually I will say, if you have an entirely virtual meeting, there's a requirement to have a telephone number. This was already in existence since 2021, where public can call in to make public comment, and you need to have access via the remote technology system if it's an entirely virtual meeting. However, even if you have a physical location for the meeting, but you are conducting the meeting via remote means, and by that I mean there are members casting votes via the remote technology system, then you have to offer at least telephonic public comment. It's a little weird the way this requirement is written in AB 219. That's our interpretation of it. I have yet to get another interpretation that would require that. I'm not positive that's what was intended. So that's actually something for anyone who would like to participate in the task force that we'll be talking about, to potentially see if there's a way we can clarify that a little bit. And then when it comes to violations, because that's a big part of what our office does, any action taken in violation of the OML is void. Our office has the authority to investigate and prosecute violations. There's also a private right of action. It's a pretty short statute of limitations, it's 60 days. Corrective action, if you believe that there may have been a violation, we would always recommend taking corrective action, because it may not eliminate the violation, but it can mitigate the severity, and it can allow you to rely on the new action. So if you take this new action and you comply with all OML requirements, even if you violated on a past one and that old one's void, the redo is valid. And you can rely on that and continue with the redo, conduct your business. It also means any action to void that original one is moot because you redid it. So you kind of, it might be noted that something went wrong before, but we often recommend, even if you think maybe you violated, take that corrective action. At least with our office's interpretation, we never view corrective action as any admission of a violation. I do want to emphasize, though, that last bullet point there, it requires an independent deliberative process. Part of the reason that deliberation is part of the meeting definition is because public is entitled to observe the deliberative process of public bodies, not just know what actions were taken. They're entitled to see the discussion, understand why their public body is taking the action it's taken. So you cannot simply rubber stamp the action that was taken at the prior meeting for corrective action to be valid. You need to redo it and pretend you act as if you didn't do the further action, with the exception of saying this is for possible corrective action. But independently discuss, it's a complete redo. So in my last 5 minutes here, I will kind of summarize, though I noted what a lot of those legislative changes were already. The quorum definition was changed that only voting members of public bodies count, and for appointed bodies, vacancies do not count. There are a number, for most elected bodies, this probably isn't an issue, but for a number of appointed bodies we have out there, there are ex officio non-voting members, and it was unclear whether they needed to appear in order to reach quorum. The meeting definition was, the language is changed, but it clarifies the existing meaning. It's just to clarify the language. A new definition was added for administrative action against a person, which triggers the notice requirement, similar to the character notice requirement. That new definition is an action that is uniquely personal to the person and includes the potential for a negative change in circumstances. So this involves if a license of some type is going to be disciplined or revoked. It's targeting those types of things. A license denial from an application would not normally fall under that administrative action against definition. And the notice periods for administrative action against a person are considerations of character. I note previously and currently when you look online, those requirements are found in 241.033 and 241.034. AB 52 is the one that changed these requirements. The way, though, LCB ended up putting it together in the bill, the numbering on those is going to change. So kind of be aware of that once the Secretary of State gets the online NRS updated. The numbering will be a little bit different. The personal service is now 7 calendar days instead of 5 working days. So it's about the same requirement, just a little bit easier to calculate. And certified mail is now 14 calendar days instead of 21 working days. So that is shortening it as well as making it easier to calculate. If the party is represented in the matter, and you know they are represented in the matter, you can serve the attorney with the notice. There is an emergency exception now for administrative action against, not for the character. This is specific to administrative action against a person. Under the same emergency exception as for meetings, the same definition of an emergency, you can take administrative action against a person. This was to cover some issues that occurred during COVID and others where a business license, for example, to revoke it or suspend it, it had to be done in a public meeting by the body. This allowed for that notice to be taken out so that when the health of the safety of the people are at risk, something can be done immediately. Full discussion maybe have to occur later. This does not take out due process requirements when they exist. The OML does not create additional due process requirements. It also does not cover them if they exist elsewhere. That needs to be considered. And there was a change to allow elected bodies, all elected bodies. There was a difference in whether or not the quorum reduction in 281A.420 subsection 5, and that's for conflicts of interest. The law formerly had that apply differently depending on the population size of the city or county that you were in. So the change in AB 52 applies the same ethical standard across the board to all bodies regarding conflicts of interest and when that reduces a quorum required to act. Other updates, I noted that public comment during multi-day meetings and the agenda posting, meetings to consider regulations or contested cases under NRS chapter 233B must have a physical location where public can attend and participate. They are now an exception in addition to elected bodies from the virtual option that was created in 2021. And I noted what most of those public comment during virtual meetings changes were as well. This last slide, which like is linked to our training materials, there is currently an OML training there from 2021, as well as an updated PowerPoint from 2023. Hopefully soon we can get the 2023 video up there. The second link there is to our OML opinions. I apologize that they are categorized by opinion number. There isn't a way to search them, but if you're ever looking for or opinions in a specific area or have a question, you can reach out to me or other DAGs that we have on call at the time. We have a few other research tools that might be able to assist. And the last one there is our OML manual. It's a little out of date, but it does have some useful information in it. And I don't know if we're doing questions now or at the end, but I'll let you guys know.
I think we'll hold them till the end. We have sort of the way we organize this, we have some time at the end. So thank you so much for that. If you'll unshare your screen, I will go ahead and have Wayne Carlson from Pool Pack go next, and I see him on camera. So you're up, Wayne. Thank you very much for joining us.
All right.
Yep, we can hear you now. There we go.
There we have it.
I don't know if you want to put that in slideshow mode so it doesn't show your notes, but there we go. Thank you.
All right. Well, my section of this is to talk about the general role of governance, board role and responsibility perspective, and also to talk briefly about civility. So the first fundamental role of the board members is to adopt a vision and mission. A vision is a statement that's where we're going to go in the future. And a mission is why do we exist? So both of those are important to guide the organization because you're focusing on what your real role is in terms of your mission, but also where are you going to take the organization 5-10 years down the road. The second element is the trustee relationship. So you act as trustees for the people that you serve, all of the constituents, whether they were ones that voted for you or not, are still the ones you serve. So you have a trust relationship with them. The next key element is to set governing policies. Now, policies are documents that express a framework for how your staff is going to operate consistent with those policies. So it's a framework that guides the rest of the organization, as well as letting the public know what your viewpoint is on how things should be functioning. The next is a fiduciary role. You're responsible for the revenue and the expenditures that come out, that are done by the organization. And your budget document is one of those elements. So that budget document has two components. It's a policy statement about what your priorities are, but it's also a tool to monitor and fulfill the fiduciary role that says the money is being spent in accordance with the policy and accordance with the statutes and regulations. The next element is a strategic plan. This is a plan that supports your vision. So this is sort of the stepladder that leads to that vision outcome. So for example, if you have a long-term plan that you need to build, let's say build a new courthouse, that's your vision. Your strategic plan should say what steps are going to be necessary to accomplish that particular vision element. So it's one of those ways to get there. And then finally is to assure that the manager actually does the job the manager was hired to do. And that's overseeing the performance as a whole. In a sense, for those with the county manager form of government, the board has one employee, and that's the manager. The manager is responsible for the rest of the employees. For boards that do not have a county manager, then several department heads become treated as if they're in a management role reporting to the board like a county manager would. So you need to assure their performance as well. And as the open meeting law requires, the performance of any of your leadership, like these, the county manager or these key department heads, that is a public performance review. So who is a board? So this is from John Nason, who wrote a book for nonprofits called The Nature of Trusteeship. And there's no other group than trustees, both deeply concerned but above the fray, to insist on clarification of mission, to monitor institutional progress, and to protect the independence and integrity of the institution. So that's a fairly high standard, but your view is the oversight to make sure that the function of the government that you are responsible for is done well and with integrity. So here's some basic skills that board members should aspire to or acquire, and hopefully before you get too far into your elected term. The first is to think deeply and broadly about the mission, vision, and strategy. It's a thinking game for the board members. This is different from operations. The managers carry out and fulfill the elements that fulfill that mission, but they're not tasked with deciding what the mission is or what the vision is or what the strategy is. They have input, but they're not the responsible party. The second is the ability to manage consequences, intended and unintended, of any decision. This is what I call the risk management component. And that's the ability to say, what could go right if this happened, if we made this decision? What could go right? And then at the same time, ask what could go wrong, and think about both intended consequences and unintended. So if you're going to launch or have a decision regarding approval of a development for your community, is that development going to have a good intended consequence? Is it going to support the taxpayers that already exist, or is it going to be a detriment to the rest of the taxpayers? And if so, how do you address those things? What are the unintended consequences? Well, they may be things you don't think about normally, but you need to start thinking about them and say, what could go wrong? If we put this project in this certain location, what are the impacts on traffic patterns, on law enforcement resources, and so forth? The next is the ability and willingness to make tough decisions. Not all decisions that come before boards are going to be routine and easy. There'll be a lot of those little ones, but there's going to be some tough ones. And so your skill is to be able to make those tough decisions and not do what a story I heard about one commissioner who decided to abstain on any controversial item because he didn't want to be responsible for it. That's not fulfilling your elected role. You have to be there and you have to participate in the tough decisions and think about those things. The next is the ability to be active, not intrusive. This means you have a regulatory responsibility, but going overboard in that regulatory responsibility would be a skill that you don't want to have. You want to hold back from being so intrusive that those business activities or those community activities can't proceed. The next is the ability to establish clear expectation and monitor performance. So clear expectations. If you're going to oversee people like the manager or the key department heads, then you want to make sure they know what the expectations are. What is their role and responsibility? What are you going to hold them accountable for? What standards are you going to apply? And then you're going to monitor them to those expectations. And that can be done in the form of job descriptions. It can also be done in the form of policy decisions. The next is the ability to delegate strategic direction and operations to staff and hold staff accountable. So you have the ability to pass on to staff certain things that they're supposed to do. And so you need the skill to know when you should pass it off to staff and when you want to hold back or have board participation or make it a joint responsibility. So those are all part of that delegation. And then, of course, attributes of leadership. The fact that you got elected shows that you are looked to by the community as having leadership qualities. And so your skill is to truly develop those leadership capabilities. So now in general, governance is the balancing of power and trust. So when you got elected, you got the power. And we'll talk about the constraints on that power in a minute. But you also had a trust responsibility. The people entrusted you to take care of their public business and do it well. Now, one of the things that can help you is a quote from Stephen Covey. It's one of his 7 habits of highly effective people. Seek first to understand, then to be understood. So this is a challenge to boards because sometimes you come into office, especially when you're brand new in the public world, and you think you know what you're doing, you think you know what needs to be done, and some people think you can run government like a business. Well, government's very different from a business. So there's certain constraints. So your first job when you get elected is to understand what your role is and what your responsibilities are and what the constraints of governance really are, both from a legal and from a practical perspective. Before you just spout off that we ought to do this, you need to understand the issues and understand the multiple perspectives that people will give you as your constituents. The next is lead, follower, get out of the way. Now, Lee Iacocca said this, others have said similar things. At sometimes the board needs to get out of the way and let others lead what needs to be done. And so you got to understand when you should step in as the leader or when you should follow the other leaders or when you should step aside and say, this is not for us. And then lastly, it's unity through diversity. This is diversity of thought, diversity of opinion and ideas. But ultimately, when the board votes, you speak with one voice, and that's the voice of the board once the decision is reached. Until that time, you are seeking consensus. You're trying to come together around an issue and trying to find solutions that are satisfactory to the multiple points of view that are presented, some of which aren't going to be accepted and some of which are, and some of which you need to modify. But ultimately, when the decision is 4-1 and you're the one, it's still your decision because it's the voice of the board. And the same with 3-2, whether you're in the majority or minority, you're still speaking with one voice, the voice of the board. So when you have your board discussions, you're having a dialogue, or you should have a dialogue, meaning that's a conversation with many points of view. So one of the strategies that's utilized in Robert's Rules of Order is that the chair of the board would orchestrate the meeting to make sure that when one person has spoken, that they make sure that the other members of the board have an opportunity to join in before that first person that spoke speaks again. That way you avoid the dominance of a single person on the board. So you want to dialogue with those many voices, make sure they're all heard, because some board members are more outspoken than others. Others, sit back and wait. So you want to encourage that participation. Next is there's a lot of alternatives going to be presented to you by your fellow board members as well as the public. So you need to consider those, and you need to be cautious and considerate when you do that, because not every idea is doable, is financially feasible, or does it fulfill your mission or vision. You can get sidetracked on issues that are not your responsibility or not fulfilling your mission or vision. One of the elements that's going to be a challenge to all elected board members and all board members is to learn what are the facts. Sometimes you get opinions that disguise themselves as facts. You need to make sure you understand what the real facts are as you go through that consideration of each of those alternatives. And then you change your thinking from what is my best idea to what is best for all the citizens I serve. So your decisions are framed in the context of the entire community, not just the loud voices, but the entire community of interest. And then ultimately, again, you get back to this one voice as a result of all of that dialogue and consideration and fact gathering and decision making. The voice of the board is the final vote on that issue. So where should your strategy be focused on? Well, first is the ends or outcomes. What are we trying to accomplish? Where are we going with this issue? Once you've decided that strategy, then you want to make sure you get progress reports on it. And then when you get those reports, you want to review that strategy and look at the deviations from strategy. Where are we not doing something that we started out to do? And then look at whether there's some enhancements to the strategy. Now that you're seeing some progress, are there any other enhancements we might want to do? And then what decisions would maximize the results? So you may have made a decision initially, but now you're a few months down the road or a year or two down the road, and you're saying there's other decisions that might maximize the outcome. And then also what new strategies arise from any roadblocks that come along the way. So all of those are elements of that strategy. Now, individually, as a board member, you have no power. You got elected to serve as a board member. The board has the power. And I've seen many examples of this where a county commissioner would try to take an adverse personnel action against an individual employee. That's not your job, and you don't have that power. I've seen it where a commissioner actually told an employee to get away from a well pump job that he was working on and saying, I can fix this better than you. That's not his job. That was not that commissioner's role. So you have no power, but it's collected when you take the action as a board meeting. So it's the board itself, whether you're a 3-member board or a 5-member board or whatever, the power is collected when the board is meeting, when the board takes action. But you do have influence because of your board position. So you got to be careful how you use your influence. And like the quote on the left says, influence is like a savings account. The less you use it, the more you've got. So you want to be careful to use your influence where it's appropriate. And of course, the ethics law then comes into play because it prohibits granting or seeking special privileges. And there's a whole series of trainings on the ethics law that are put out by the Ethics Commission. And I also do a training program on ethics as well. But the key is the ethics standards are derived from the fact that you have a position in which influence can be unduly exercised. And that could be a violation of the ethics standards. So now we're into the next key part, which is decisions. That there's change ahead. You're going to make decisions. So decision making is the most important role of governance. That's what you're elected to do, is to understand and analyze issues and make decisions. Your decisions should be based on policy. Now, policy is the U.S. Constitution, federal laws, state constitution, state laws, and local ordinances, and your policies. Those are all the policy influencers. And you want to be consistent. When you adopt a policy, it should be consistent with any ordinances you have and consistent with any state law and so forth. You can retain or delegate some of your decision making, but by and large, it's going to be on the board to make those decisions. So how do you govern yourselves as a governing body? First, you need to clarify what your role is. And I remember a county commissioner who was a planner by profession. He has a professional planning consulting business. And he got elected to a county commission. And when a planning issue came before him, he dove into it heavily, grilling the planners' documents, looking and asking questions as if he were a planning consultant. And then he stopped himself and he looked at the county manager and he grinned, and the county manager grinned back. And then the board member said, I'm the board member. That's operations. I'm getting into the operational weeds. I need to shut up. And they both laughed, but he recognized there's a role difference. So board members have a policy role, staff members have an implementation. So it's important to ask questions, but also to understand your role. So one of the things boards can do is to define your information needs. How do you want to be prepared for a decision? Some members want to have the written documents. Some members want to have a staff presentation in addition to the written documents. Some members want to go to the job site where the project's going to be and walk the site, look at the plans from that perspective because they need that visual experience. Some want all three. So you as a board should decide what is the best approach for us to ask of staff to help us be prepared to make good decisions. And that's a good discussion to have between your fellow board members and your staff in order to define those things. The next, of course, is to relate to your constituencies. You want to have a relationship with the public. You want to maintain that. It was part of the reason they elected you, was so that you could take care of things on their behalf. So it's important to relate back to them and to say how we're doing as a board. The next element is sometimes very difficult, and that's self-discipline. That means the board members have to discipline fellow board members who are not serving the public well, who are violating the open meeting law or violating the ethics standards or violating the board policies. And I'll give you an example, and this goes back a number of years, but we had in this case, it was a city, a newly elected council member on the record, just as the clerk turned on the tape, he propositioned a woman in the audience by saying, "Hey, babe, how about you and me getting together right here, right now? What do you say?" Now, that violated their personnel policies. It violated local law. It violated federal law, because that was a harassing statement. So what was the board supposed to do with that? Well, because he was newly elected, the citizens couldn't take care of it. They couldn't recall him from office if they wanted to. They had to wait at least 6 months. So the board chose to censure that member, formally on the record, admonish him that his conduct violated the standards that the board was holding each other to, the policies of the organization, and the law. And they made him acknowledge that he had committed that violation. That's board self-discipline. And that's tough. It's tough to do, but it's necessary for the integrity of the board. And then next is balancing control. Again, the chair can orchestrate the meeting, but the chair wants to make sure that each member has the ability to contribute to the meeting and to ask questions and make comments without bias or prejudice, but so that no one member feels excluded from the conversation. So that's balancing the control. And then, of course, use your time productively. Make sure you have meaningful things on your agendas, things that you can seriously look at as fulfilling your vision and mission, and have meaningful discussions on what that vision and strategy might be. So use your time to productively work on these long-term key issues. So here's the conflict that often results. On the left side, under the vision implement, the board's role is to set the mission, vision, goals, adopt policy, approve the budget, oversee the results, be accountable to the people, and assure the manager's performance. On the right side of the screen is the management role. The management should do these things. They're the doers. You're the policymakers as board members. Give input, offer guidance, prepare the budget, conduct the operations, carry them out, carry out the board policies, do what the board delegates, and do as guided in collaboration with the board. So there's two different focuses, but it's a collaborative relationship between the board and the key staff. So let's talk about civility. We've seen a lot of what's called fresh squeezed discord in this cartoon, and very little use of the refreshing civility. And we need to move toward that civility. In fact, the National Association of Counties some 20 years ago published In Search of Civility as a guide, because things were already starting to develop negatively. So here's a quote from Dick Clark, who was the head of the Peace Officer Standards and Training. I attended one of the classes he gave to his highway patrol officers and local law enforcement officers called Dealing with Difficult People. And this is what he said. Conflict is neither positive nor negative. Now, I would challenge that most of us have not seen conflict as both. But conflict, if managed properly, it's an opportunity for personal growth. So your challenge as board members, especially in a public comment environment, is to look at this conflict as maybe it's positive, maybe it's negative. But can I manage it? How can I grow? It's an opportunity for me to grow. If mismanaged, it can be destructive personally and professionally. Our purpose is to maximize positive benefits and minimize negative impact. If law enforcement officers can adapt these principles, so can boards. So the important thing is that when there's a comment by the member of the public, they could be right, they could be wrong, they could be misinformed, they could be uninformed. Your job is to accept them as they are and try to change their approach to be a positive one. And so that's the civility challenge. So how do you do that? Well, one tool is to ask an open-ended question. So, for example, if a public commenter is angry and challenging you, then ask them, how can you restate, so I can really understand you, how can you restate what you're requesting of us in a civil tone? Because the angry tone is making it hard for me to listen to what you really want. So you're asking them to re-engage the thought process and to move away from just the confrontation process. So you set the tone as board members between each other. So you need to walk the talk. So you need to expect civility of each other. And I've seen dysfunctional boards that don't do that. And it's really disservice to the public and to each other. So one suggestion is to read a statement before public comment, emphasizing that you have a culture of civility. And that presumes that you're going to walk that talk as board members. Welcome positive ideas, welcome constructive critique of the board, of you individually as a member of the board, as on all issues. And then confront the negativity with candor and civility. That means when that speaker is angry, confront that anger by saying, I feel your anger, I understand that you're angry, and then request that reframing by asking the open-ended question that's not a yes/no, because you want them to re-engage their thought process to rethink and restate in a civil manner. And so it requires some effort on part of the board to get that negative viewpoint to be restated in a more positive civil manner. But consistently doing this will reduce the amount of animosity in the public meeting between board members and between board and staff and between board and public. So citizens, from their point of view, the structure of the government, whether you got a county manager or don't, doesn't matter as long as the trash is collected, the dogs are picked up, the crime is low, the potholes are fixed, and the government is fiscally responsible. They want a well-run government. So your challenge is to what best meets the needs of your citizens. How can you deliver a well-run government that meets their needs? Because that's what they elected you to do. Not to pat yourself on the back, not to exert your alleged power, but to meet their needs. And so that's the challenge. So that's mine.
Thank you, Wayne. If you want to unshare. So thank you for that. Again, we'll hold questions till the end. Want to allow, we save the best for last, Dan.
Oh,
So, just kidding.
is there somebody coming up after me?
Yeah. I'll introduce Dan Hughes here in person. So hopefully if you guys have issues, if anyone on the Zoom has issues hearing or with volume, let us know, please. But otherwise I'll turn it over to you.
Great. Well, thank you. Well, and good morning, everybody. First of all, I want to say thanks very much to NACO, to Vince and to Jennifer for reaching out to Carson City in my office, the DA's office in Carson City. And thanks again for my bio introduction earlier this morning, Vince. As he had noted, I was a legislative attorney before in the past for almost a decade. I have worked with NACO on and off in various circumstances. It's always a pleasure to be back here. Gosh, it's kind of a tough job for me to follow my colleagues Rosalie and Wayne. They put on excellent presentations. I'll do my best to sort of meet these expectations. I do apologize in advance to everybody in the audience who's listening. Unfortunately, you're gonna have to be bored with my voice alone without the aid of any visual presentations. I did not bring a PowerPoint presentation, but I'm actually glad that I did not, because Wayne's PowerPoint presentation with the animation included, for example, is something that I cannot match this morning. Speaking of Wayne's presentation though, however, I'm actually going to latch on to something that he said earlier in one of his slides, and I'm going to use that as a segue into my component of this morning's discussion. And what he had spoken about was, attributes of leadership. And when we talk about best practices in Carson City with respect to abiding by the requirements of the open meeting law, I think those two concepts really sync up. So, what Wayne, in my view, when I was watching and listening to the words that he had for everybody today, I perceive that as a very moralistic view of what it means to have proper governance, to engage in civility. And really, when we're talking about sunshine laws like the open meeting law, what's that all about? Right. It really, for me, what it does is it creates sort of a baseline statutory framework for the best and most efficient conduct of a meeting. So certainly there are statutory requirements, and it says you may or you must do X, Y, and Z. But for me, this is one of those rare circumstances in life where more is better, and it's not less is more. And what I mean by that is it really sets the stage for minimum compliance, and really what you ought to do is a minimum baseline standard. And there's certainly nothing, as Rosalie and Wayne said earlier today, that would prevent a local government or any sort of a governing body of a local government or any other board or committee or commission from going above and beyond. And I think that sort of links back to this idea of what does it mean to exhibit these important and critical aspects of good leadership when you're elected into a public official position. And really, you're there to be a steward of the citizenry. And what the open meeting law does, along with Nevada's other sunshine laws, is it's supposed to promote civic engagement. It's supposed to facilitate channels of communication. And when you take those two things together and you combine them, really what it's supposed to result in is an improvement of the health of the body politic. And I don't mean to get too philosophical or esoteric about that, but I'll give everybody an example of what I mean by fostering civic engagement and why that's a productive thing. Obviously, I'm sure we've all at some point in our lives been on the phone with a customer service 1-800 number, and you're on the line for 5, 10, 15 minutes, and you're speaking to an automated voice. And all you really want is to be heard and to speak to a live person, a live voice. And a lot of times what I've seen, in public meetings is that's exactly what the citizens want. The community at large, they want the opportunity to engage with their community leaders who've been elected or appointed into their positions. And they want to be able to provide their own personal feelings, their input, their constructive criticism. And that's what leaders should be there to understand, to listen, to take in, help build the right decisions off of those community concerns, along with their own personal policies and political platforms. What are some of the best practices for Carson City? And I draw from my own personal experience professionally as the counsel for the Board of Supervisors here in Carson. Obviously, we look to the statutory language on a frequent basis every time there are legislative updates. Fortunately for us, as Rosalie had gone over in her overview slides, there were not a lot of changes in 2023 or in 2021 for that matter. But we certainly keep up to date. We watch for pending legislation. We look at what's being proposed and what's being discussed during legislative sessions. But it's more than just keeping up to date as a bare minimum. We are constantly looking at ways to optimize how we conduct our public meetings in Carson City. So what that means is, and really, I'm blessed to have a great client, the Board of Supervisors. I work with them very closely on a daily basis. I work very closely with the mayor and with the vice mayor and with all the individual supervisors. I'm fortunate to have an excellent team of civil attorneys in the DA's office. And what we do is we sort of ping pong back and forth very frequently on what is the best way to agendize something. We look at the formatting, the sequential organization of our agendas, the hard documents themselves. And I have a lot of collaborative effort roundtables with my clients to determine from 1 month to the month, okay, what did we do right last month, and how can we improve upon that? That's something that my clients task me with. So I'm not in a position, and I view myself as being in a very fortunate position where I don't have clients, and I certainly don't have an office philosophy at the DA's office in Carson City where we're just completely satisfied and content with doing things as they've always been done. Which I don't think is a good approach to government, and I don't think that's a good approach to implementing the open meeting. We want to look at it. We're not just trying to satisfy it. We're trying to go above and beyond to optimize transparency in government, which is good for both my clients, the public officials or the appointed officials, as well as the community at large. To dive into more specifics, one of the things that we're always looking at is consistency in the agendas that are prepared. That's maybe something that not everybody looks at on a regular basis. In Carson City alone, and I'm sure this is the case for a lot of other counties and cities, is that obviously we have a lot of different public bodies. Just to sort of rattle off the top of my head, aside from the governing body in Carson City, which is the Board of Supervisors, we have the statutorily required Planning Commission. We have the Historic Resources Commission. We have our audit committees. We have our, Parks and Rec Commission. We have our Regional Transportation Commission, our Carson Area Metropolitan Planning Organization, so on and so forth. And all these public bodies are obviously subject to the open meeting law. What we want to help facilitate is an expectation of consistency when you have your community come into these meetings and they pick up that agenda, that piece of paper. We don't want it to be too jarring. We want things to be across the board as uniform as possible. And that doesn't mean, down to every nut and bolt, because certain agendas by nature of the contents of the matter being discussed, maybe necessitate a slight deviation from one document to the other. But by and large, the contents of the notice and the agenda should all be about the same. And this way, when a person who is from the public, who wants to be in the audience as a member, and they pick something up, they sort of know and already can trust that, hey, I've seen this before. I know what the conduct of this meeting is going to be like, and I'm not going to be misled into thinking that, hey, over here, perhaps when I attended this meeting, there was some sort of, for example, a public meeting or a public comment restriction that I'm subject to, whereas over here I'm not, or vice versa. So that's something that I do advise my clients in the city to do when I speak with the city manager's office, for example, and I ask them to issue these directives to different staff for facilitating the preparation of these agenda notices. Proper language development for each specific agenda item is obviously very, very critical. That's certainly an area where I know there can be accusations that, the open meeting law has been violated because, the language is not clear, it's not complete, and that those are components that are required by, this regulatory framework we have. So, but what does it mean to be clear and complete? I'll give you some examples. If you simply say this is an action item or a presentation item to discuss a plan of the city involving the roads, is that clear and complete? And I would say no, because if you're the average citizen, you're reading that, you have no idea what that's intended to encompass. It can mean any number of things. It can mean contracts, it can mean directives, it can mean policy implementation. So when you look at the open meeting law, the case law, and then also the Attorney General's opinions over the decades, you'll see very clearly that although there isn't a bright line rule with respect to how to implement clear and complete language, there are certain guideposts that we can all go by. You want to make sure, and for me, sort of the baseline test here is when you read the agenda, ask yourself, stepping back for a moment as John and Jane Doe from the public, when I read this language, do I understand what it is that this public body is going to be addressing at this meeting? And if I don't fully understand what it is, then it's probably not clear and complete. When it comes to contracts, for example, you always want to be very specific with the parties, with the effective terms, the money that's involved, that's going to be proposed. But there's another side to this too. I don't ever want to hamstring my board into an up or down vote. So I try to balance or strike that proper balance between what's clear and complete against providing a little bit of flexibility, a little bit of leeway. And you don't want to lean too hard into that because then it becomes a vague or overly broad or ambiguous agenda title. You want to provide some leeway. So again, I'll give you another example. If you were to pull up a Carson City agenda from the last 2 or 3 or 4 years, you'll see that across the board, normally the language will be for possible action for an action item, discussion and possible action relating to a proposed contract between Carson City, Acme Corporation for the effective term of these dates for this monetary amount. Now, because it's something that relates to this, and it doesn't say, for example, for possible action, a contract to approve, you can kind of move away from and mitigate against these allegations that, hey, as written, if it's just simply to approve this contract for this amount, it's just an up or down vote. Now, I know that the Attorney General's office has issued opinions in the past with respect to, for example, naming certain buildings or structures or historic places in a county. I can't remember the exact year of this Attorney General's opinion. I have read it before in the past, where I think the context of it was staff's recommendation to give this name. And that was very specific. And what the Attorney General's office said was, no, that's not an up or down vote. The public body certainly had the discretionary latitude to deviate from that recommendation and name it something differently. But when it comes to something like a contract, to a policy directive, something that's a little bit more finite, I think one of the best practices here that I can advise my clients is, let's try to strike that proper balance. And a lot of that onus shifts to the DA's office, to myself and other board counsel, committee counsel who are assisting with the preparation of that language. So a lot of that, really falls on the legal side of things. But other things like, don't use acronyms. Again, that sort of ties into this concept of if you're reading it, try to put yourself in the shoes of, the citizens. We may all internally in the city as staff, as the attorneys, as the elected and appointed officials, have been working on something in concept in various roles for a number of months, weeks, maybe even years. And because it's something that's routine within government, you may automatically assume that when I refer to something using acronyms, everybody else is automatically going to understand what I'm talking about. So if you have an agenda item, for example, that references, hey, we're going to implement or discuss a policy with respect to the use of allocations that were received from the federal government under the ACA. Just spell that out. It's the Affordable Care Act. If you say FLSA, let's go ahead and spell that out. It's the Fair Labor Standards Act. If it's the ADA, you want to spell that out initially in the agenda title. But then what you can do is, to avoid repetition, put that in a parenthetical. And then later on, you can reference back using the parenthetical itself. So it's not to make it so that the agenda title is overly long or overly burdensome. Nobody wants to read an agenda title that's 1.5 pages long. That sort of defeats the purpose of things. But at the same time, you want to make it so that's clear, it's concise, so that a person who's picking up the agenda, and maybe this is their first meeting, you can't have this expectation that everybody who's following an agenda has been doing it for years, or that they're completely in tune with what everybody else, from city staff to the elected official is talking about. So I try to spell everything out when I can. But speaking of length, I mean, that's another thing that I want to address as well. You want to look at it and make sure it's not too lengthy. You have to ask yourself if this agenda title is more than a few sentences long, and if there are actually several sentences, are you inadvertently combining too many topics for one discussion item, for one action item, where really that should be separated out for purposes of inviting different motions. You don't want to conflate things too much. And I know that some, public bodies can get tripped up and accidentally fall into this trap of saying, hey, these items are germane. And even for discussion purposes, they may say, hey, I think I'm not deviating too much from the scope of this agenda title because I think this all relates back. It's somehow germane. And the Nevada Supreme Court has ruled before that, the germaneness standard is not really a standard that you apply in implementing the open meeting law. It's something above and beyond that. So it's maybe not quite strict compliance, but, you look at the text of it, the plain meaning of it, this is what the statutory requirement is. This is what the defined parameters using the language of the agenda title says you may speak about. And if that's not addressed, you can't simply say, well, I think tangentially this relates, and therefore I can speak about it. That would be too much of a deviation, in my opinion, and probably a violation of the open meeting law. We use in Carson City staff reports, we use this program called Granicus in building our agenda notices. And I don't know if that's something that every county uses, but that is a vendor that we have hired several years ago. I think we've transitioned, and this has happened right before I came on board in 2016, from sort of a roundtable approach of different stakeholders in the city coming together in person and going over the agenda manually, versus what we do today, which is we've got this program, everybody can get into it, provide comments, and you can sort of make your revisions and changes there. But as part of this program, what we provide on our agenda notices is, in addition to just the titles themselves, we have, following the titles, a staff summary. So that, again, that provides another layer of additional information to the reader. And that's, again, what the whole purpose of this is, to promote transparency, to give as much information as possible, not to withhold information. We also provide staff reports. I mean, staff reports are not required by the open meeting law. I mean, they're submitted as supporting material, And there are certain requirements statutorily that go hand in hand with what has to happen with supporting material, but the creation of the supporting material itself is not required by the open meeting law. But what we do, again, as part of this Granicus approach, using this vendor application, is that we have, full-on documentation prepared by staff in consultation with my office and the attorneys in the civil division that sort of helps summarize the procedural history of how we got here today before the board for an item for consideration, but then also the legal aspects of it and sort of an explanation of why we're asking this public body to give directive or to take a motion on this particular matter. And again, that's for purposes of just promoting transparency, giving more information. I always ask my clients to be generous, be liberal. That's what's required when it comes to interpretations and implementations of the various provisions of the open meeting law. Go above and beyond. There are, however, no constitutional, statutory, or common law requirements that just because you have an item that is denoted as for public action, as an action item, that you have to take action. So in that sense, and that's generally speaking, I mean, there are certain exceptions where a public body is obligated, to consider something and cast a vote. Generally speaking, however, there isn't this, administrative rule that says you must take an action on everything on an item, even if it's denoted as for a possible action. So, one of the things that I ask my clients to really consider is, are you certain? And building these agenda notices, are you certain that this is just an item for discussion purposes only? Is this solely an item for presentation only? Or is there a potential where in the course of this discussion, this body as a collective group may want to give directive to staff to come back and follow up on it? Maybe they want to direct staff to do something. Maybe they want to take action on something in relation to this topic of discussion. Well, in that case, I say, err on the side of caution and list it, denoted as for possible action. Because again, as I said before, just by denoting something as possible action does not mean you have to take action, but by not denoting it as an action item, you're prohibited from taking action. So that again just gives, another, option to my client in determining on the record whether or not they want to go in a certain, direction. I do want to talk about site visits for a moment here when it comes to certain things that different public bodies do, and I'll start off by saying, with a disclaimer that I'm not categorically in objection to site visits, to field trips, if you will. But generally speaking, I disfavor them. Now, I understand the concept of a public body and a quorum going off-site, away from its normal venue where they hold their meetings, because they want to actually see and be physically present at a location that may be a topic of concern. So let's say, for example, a planning commission may want to go to a site where there's a proposed development, or in determining whether or not to approve a tentative subdivision map. The governing body of a local government, the board of supervisors in my case, if they say, hey, it might be good for us to go out and lay eyes on these parcels ourselves and see how these neighbors border this parcel that's proposed for subdivision, because we're getting a lot of concerns from the community. We've got homeowners who live in adjacent properties who are criticizing, these plans, and maybe we want to go out there and lay eyes on it ourselves. And I understand that. I get that. There's certainly value to be extracted from that approach. On the other hand, I think that's offset by some inherent dangers in these site visits, which is, it's really difficult for staff or for legal counsel or for the public members themselves to monitor what's being said, right? It may be difficult for the clerk recorder's office or their staff to, take proper notes, for purposes of minutes, production later on. It's difficult to make sure that there are no inadvertent deviations from the conversation for which this site visit is confined to, and all of a sudden now you violated the open meeting law because you've deviated from the scope of what this trip is about. So there are a lot of dangers, and quite frankly, for myself as legal counsel, I mean, I'm getting a little long in the tooth myself and not nearly as sprightly as I used to be. I would prefer not to go out on a trailhead and walk around in my suit and tie. But again, I understand sometimes there's value. If there ever is going to be a site visit, I always recommend that you have a game plan in place. You don't want it to be a free-for-all where it's very much like this, a school field trip, where it's just a gathering of people and they're walking around and everybody's speaking at the same time. It's nearly impossible to take minutes for that. You may have people who walk off and then all of a sudden you don't have a quorum. If you have a majority of your members off on a sidebar, you don't really have the ability to monitor what it is that they're talking about. It can be a bit chaotic. So, my recommendation is, again, not to say categorically don't ever go out on a site visit, but if you do, make sure you've got those plans that were established well in advance so that you can streamline that sort of a visit. Public comments, obviously a huge deal. You heard Wayne saying earlier, hey, let's be civil. I mean, there's a lot of importance placed on this concept of civility. And that's something that I think, people forget about, from time to time. We're all human beings. We naturally can be defensive sometimes when we're accused of things, when people, want to try to erode your character, sully your character on the record in public. Again, I'm blessed to have a really, really positive, forward-thinking body of members. And by forward-thinking, I just mean that, they're very receptive to communications, receptive to input. It's important during public comment periods to allow the person who's speaking, who's testifying as a member of the public, to speak their mind. Now, certainly there are limitations. I mean, reasonable time, place, manner restrictions. You don't want them to be overly repetitive, for example. You don't want them, to be slanderous. You don't want them to be inflammatory. You don't want them to be obscene with their gestures, with their language. I mean, these are sort of common sense, pragmatic limitations that various courts have said are okay with respect to restrictions on this type of speech. These are not town hall meetings. These are not street corner meetings where it's a public space. These are limited public venues, public forums, where these reasonable time, place, manner restrictions can be imposed on the person who's speaking. But it's important to be civil. So if the person comes up and they want to criticize what's being done by the quote unquote government, let that person speak. I mean, they may have some valid concerns, some valid points. Everybody's got valid points. There's really no necessity in engaging in a back and forth in a Q&A. One of the problems of that is that although a member of the body may be thinking, hey, well, this is what I'm doing, I'm engaging with the public, what we really need to remember is that the public comment period is really for the purpose of allowing the member of the public to speak. It's not for a Q&A. Give them their time. If there's too much back and forth, and I'm not saying that there's no occasion that warrants a little bit of back and forth, but if a public member wants to speak and then the public official intervenes or interjects with their own opinions, with their own retorts, with their own answers, what you've done is you've cut into that speaker's opportunity to provide their input, their ability to engage with the members of this public body. And so we want to be mindful of that. Certainly restrictions on time, as alluded to earlier, that's okay. You just have to state that clearly in the agenda notice so that members of the public understand that there may be a restriction, a time limitation placed on, their public comment. There's no mathematical exactitude, I would say exactness, with respect to how much time needs to be afforded to each speaker. I do know from reading case law in the past that there's at least one case that says, hey, a public body's implementation or imposition of a 3-minute time restriction was totally fine under the circumstances. It was reasonable. It's a reasonable time, place, manner restriction. A lot of bodies here in Nevada, I've seen from various agendas, will impose that 3-minute time restriction. It doesn't mean, however, that 2 minutes is unreasonable or per se unconstitutional. 3 minutes seems to be something that everybody feels comfortable with. But what do you need to do with that 3 minutes? Does it mean every person needs to get down to the second exactly 3 minutes, especially if there is some Q&A, some back and forth? No, it doesn't. It just means you need to get that person their fair shake. What you don't want to do is to afford a 10-minute conversation or a 10-minute opportunity for one person to speak, even though you've imposed a 3-minute time restriction, and then you say to the next person, well, you only get 3 minutes. Well, that's not just inherently unfair, but that's probably or could be construed as viewpoint discrimination. Well, I'm going to allow this person to speak for 10-12 minutes because I like what they're saying. This person, however, at 3 minutes down to the second, I'm gonna slam down my gavel and say, I have to cut you off. You've exceeded your 3 minutes. Well, that's sort of from an optics perspective, at a minimum, seems to show that, well, I'm cutting you off because I don't like what it is you're saying. Now, that's, again, it's unfair, but it's also not in accordance with time restrictions. You want that to be applied uniformly across the board. Parliamentary procedure also sort of comes into play, but again, it kind of goes hand in hand with this idea of allowing everybody to speak and having their reasonable opportunities. But what I mean by parliamentary procedure is there has to be this efficient conduct and running of these meetings. One of the things that I dissuade my clients from doing, in Carson City, like a lot of other boards, are very informal. I mean, we're not this, uber formal board. My clients, the members of the board of supervisors, like to engage with members of the public when somebody comes up to the witness table and they present their testimony and they say, hey, I've printed out these documents. I've got a few copies with me. And what I would love to do is to start handing out copies to each of these members so that you have it in front of you as I go down these talking points that I'd like to share with everybody today. I like to remind members of the public, and I work with the city manager who happens to sit right next to me, behind the dais. Hey, let's go down, or let's ask this member who's providing these hard documents to give them to us. Now, I want to receive them for various reasons. Number one, I want to make sure that there are sufficient copies. We don't want to violate the open meeting law by doing something that's easily avoidable. A copy provided to each member on the body, but none that is provided to the members of the audience. So at a minimum, you got to have one copy, in that back table. That's what's required by the open meeting law. When supporting material is given to members of the public body and they're reviewing this, they're going to rest their decision, at least in part, on what they're seeing here. You have to provide that simultaneously at the same time to the public as well. So I want to make sure that we've got enough copies. If there aren't, we have copy machines nearby, we can run extra copies. But another thing that I want to look at too is I want to make sure that the material is not obscene. It's not inflammatory. That's something that we want to look out for. It hasn't happened, but doesn't mean that it couldn't happen. But then there are other nuances to supporting materials. Several years ago, I wrote a short article for the Nevada Lawyer because this was something that I'd come across during my time as a legislative attorney at the LCB. a lot of times what happens, people would send in supporting materials, and in reviewing this, what I would notice is that, well, it's not just their own handwritten testimony, their own letter of concern. A lot of times what people do is they'll go online and like what I do from time to time, I Google for information. But what people will do is they'll hit that print button and they'll print out an entire article from the Wall Street Journal, or from the RGJ, or from the Las Vegas Review Journal. But what they do also, I've seen, is they'll go to a website where it is a subscription or paid service only, and they'll print out a 30-page white paper, a research paper, that helps to bolster or support the position that they're going to be presenting during their testimony. And I've gone to these websites and I see that in order to print out this white paper that's 30 pages long, that was authored by a scientist, by somebody who's in academics, you've got to pay $20, $30 for this. Now, this is a paid service and it's copyrighted. What we don't want to do is to inadvertently violate US copyright laws. Now, that's not addressed in the open meeting law, but US copyright laws under federal regulations, that supersedes our state laws. So what the United States Supreme Court has said before in the past is that 11th Amendment immunity from these types of federal lawsuits in federal court under the US copyright laws, that does not extend to local governments. That's been abrogated, with respect to state lawsuits, but with state defendants, but with local government defendants, you're subject not only to injunctive relief, declaratory relief, but also for compensatory damage, for statutory damages for violation of the copyright laws. There are, of course, as you all know, as government attorneys, there are certain fair use exceptions under that doctrine where a government body may be able to use certain portions of copyrighted materials, reproduce them, post them, so on and so forth. Case-by-case analysis, lots of elements to explore, one of which is, hey, are we using this for the intrinsic purpose of this material that was authored by somebody, by that copyright holder? Now, I don't profess to be an intellectual property attorney. I don't profess to be an expert in, US copyright laws. In many instances, the use, the reproduction, the posting of copyrighted materials by governmental entities, such as a local governing body of government, is acceptable. Other times it may not be. I'll give you an easy example. And also part of this is just sort of fairness. Aside from this scientific author who has written a paper that specifically may only be made available to the public through this subscription service, or if you pay for it for a download, it's not fair to that person if you repost that, if you distribute that, because it's obviously for profit. But what if somebody says, hey, I want to present my testimony and help bolster my position. What I want to submit for the record is this entire Time magazine. Well, what do you do with that, right? Are we expected as local governments to accept that entire front page cover to back cover, that entire magazine, that March issue of Time magazine, and repost that on our website and distribute that? That's obviously copyrighted materials. The best practice there would be, in lieu of reposting that, redistributing that, republishing it, would be to provide a bibliography. So as part of the minutes, and as also part of what you post online, and what you provide to your clients who are the members of the public body, instead of giving them that whole Time magazine in reproduction, give them the citation to it. Give them the bibliography, the volume number, when it was published, where they might be able to find a copy of that. Many times, these articles that are ripped from the internet that a person might want to submit, you can provide a link to that by simple Google search. So that's what we did as a matter of course during my time at the Bureau. That's what we do as a matter of course here in Carson City when I'm providing legal counsel to my clients is, hey, let's just go ahead and mitigate against any potential liability, any potential violation of US copyright laws. We'll make it easy on ourselves without having to engage in this case-by-case analysis. Let's just provide a bibliography in lieu of this. Now, that's, again, it's not applicable to everything. Certain excerpts of articles I'm perfectly fine with. It's mostly just when somebody wants us to reproduce an entire article that was authored by a private party, an entire chapter of a book, or a white paper that clearly you can only download or be in your possession if you paid for it. These are sort of our basic best practice principles that I've decided to select for today's presentation. I mean, with that, I'm going to turn it back to you, Vince, and I'm happy to take any questions. But at the end of the day, when it comes to acting in accordance with the open meeting law, I'd say there's a lot of nuance involved, and a lot of it is just sort of a common sense approach. Yes, as a legislative attorney in a former life, by and large, I'm a textualist. I go by the plain language of the statute. I believe that is the best evidence of intent. Intent is controlling. You derive intent by what the words say. But you can always go above and beyond that. That there's nothing in statute that prohibits you from going above and beyond.
Thank you, Dan. Thanks to everyone of our panelists. I do want to open it up, allow sort of like the last 15 minutes or so here for some questions. And while folks maybe are coming off mute on Zoom, maybe I'll start and see. We have a couple of folks here in person. I might see if either of them have a question. If not, I'll turn it to some of the folks on Zoom. If no one has one, I have a question actually that might be worthwhile, but I want to ask folks on the Zoom, if anyone has a question, feel free to unmute. If you're on the phone on Zoom, it's *6, and then make sure your handset's unmuted, or you can come off mute on your video. I don't see anyone. I'll sort of give people another opportunity. I have a question that I think might be good to expand on just a little bit. Maybe, and it pertains to open meeting law. I know we talked about open meeting law and good governance today. I thought maybe because compliance, I seem to hear a lot of feedback from our member counties on compliance. And what I thought I would do is ask each one of the panelists to provide maybe like a tip. I know Dan did some best practices, but at least for how they conduct business. But I thought maybe it would be good to do sort of one tip from folks. Sorry to put you all on the spot, but for our folks that sort of leads, maybe Rosalie would be a good start, just around because you receive most of the violations. So if you could maybe share themes of violations, and then sort of what you would suggest, recognizing that it's not legal advice, but maybe just a tip. So.
I mean, I noted a couple areas in the presentation of areas that we get a lot of complaints. Public comment is often one, supporting materials and other things, but a lot of times what's motivating the complaints, or what it seems apparent is motivating the complaints, is complainants feeling like something is being hidden, or sometimes it's purely they don't agree with the decision being made and they're trying to find a way to undo it or force that. And to the extent they don't agree with the decision being made, there's not a lot you can do, right? You've been elected or you've been appointed into this position to make these decisions, and not everyone's going to agree with the decision you're making. But to the extent that it's this feeling that something's being hidden, or that public voices are being ignored, that is definitely an area. And so I guess the tip I'd give is, the other presenters here talked about this as well, is there's the minimums under the OML so that you've complied, but there's also I've seen bodies at times have almost an attitude of us versus them when it comes to public comment. And I guess I would really say, listen to whether it's your constituents or the public that attends your meetings, the public that is involved with your body. what fits when it comes to your public comment or other things you do in your agenda. Really look at the procedures you're doing and what seems to be appropriate for your body. And I take that also into consideration to the extent you're using virtual meetings or in-person meetings. First, depending on what a body does and what the type of meeting is, you know, there may really be no reason to have a physical location. Some of the bodies, state entities we represent, they rarely have more than one public member in attendance. But a lot of local government bodies, there's a lot of people who live close and really want to be able to see their representatives and shake their hand and talk to you in person. And I guess, so to the extent it looks like you're structuring things just because it's a way that is convenient for members, I encourage you to really look at what your public wants in that sense. And the more you can structure for that, the less likely you are to receive complaints about it. I know that that's kind of a roundabout, and I don't know how much that makes sense, but I guess the tip what I'm trying to get at is when it really appears that the public body is trying to listen to the public and trying to be open and work with their public, and I get less complaints on those regarding how public comments conducted and things like that. There's the complaints I get usually have to do with maybe things happened technically in compliance, but it was an attitude of not listening to public and trying to shut them down that caused a lot of complaints.
Yeah, so I guess the way I would summarize that, sometimes I personally am okay with negative feedback sometimes, because I sort of think you have to approach public comment as an opportunity, not a burden. And I know it's become burdens in theory to some across the state because the meeting times have gone longer, but I guess I just would approach it that way. Wayne, do you have something that you want to share? Maybe just a compliance, sort of a helpful hint on compliance?
Yeah, I think it's incumbent on the boards to have set their own policy and protocol on how their agendas are going to be set. And I appreciate the comments about how Carson City organizes its agendas and gets that input. Not everybody does that. Sometimes it's done because you only have a 3-member commission. It's done by the chair and the clerk, and they may not get that other feedback. So it's important to, as part of your preparation of your agendas, to be clear, to have that input. And so that needs to be addressed, you know, in a policy format. And then in terms of public comment, you know, a lot of times it's not artfully presented, let's put it that way. But they could be well-meaning. But there's also situations where, like one county had a citizen that decided to read from a novel. Well, you don't have to listen to that. That's not pertinent to your business. Or another situation where a county was approached in public comment by a citizen who was complaining about the school board, over which the county had no jurisdiction. So it was right for the chair of that particular commission to deny that comment, to say it's not relevant to this board's jurisdiction. So you have to understand when it's relevant, when it's not, but also welcome the communication from the public about what they're seeing. And it's something I've said in other presentations, but it's a chance for the commissioners to get their own degree, management by wandering around. It's a way for citizens to wander into the commission and give you input that you might not otherwise get, even though I know a lot of times you get cornered in the grocery store with questions. And then the other thing I guess I would add is when you are approached outside the meeting for answers, you need to be careful because of the perceived power that each commissioner has. It's perceived that you're making a promise potentially. And so I like to characterize it as input, and that's how you should see it, as this is input, and I appreciate the input I'm getting from the citizen, but not make a promise, because that's a decision by the full board.
Oh, that's great advice. Thank you, Wayne. Dan, you want to maybe touch on one?
Yeah, sure.
Things, but maybe just to highlight.
Sure. No, and these are all good tips and advice. I guess generally speaking, what I would say and reiterate is public bodies should really in earnest try to embrace the open meeting law, right? And not feel as though, hey, this is a burden. I mean, the open meeting law, again, what's its intended purpose? It's to promote and to facilitate good government through transparency. And what we ought to remind ourselves of is that, citizens at the end of the day, they've got a vested interest. You yourselves, myself, we have a vested interest that our elected officials, our appointed officials who are making these really important decisions for us, are receiving our input, our voices are being heard, and that they're exercising the best and most prudent use of taxpayer dollars at the end of the day. So I say don't resist the open meeting law, just embrace it. And when you embrace the open meeting law and you are always trying to further transparency, open communications, it's actually a regulatory or statutory framework that's not very difficult to act in accordance with. It's just about being open. But specifically with respect to an actual, tip, I would say, and this is something that I'm sure a lot of other board councils have seen. I'm sure you've reminded your own clients of, is what I call the post-meeting impromptu meeting, right? And what happens a lot of times is, a meeting's wrapped up, your microphones are off, the cameras are off, and you've run through the entire agenda, and everybody's up and milling about. And as you're exiting the doors, all of a sudden, inadvertently, you have a simple majority, a quorum of that public body who's now gathered in the hallway, and they start talking about what just occurred, what just happened. But then sometimes what that does is it translates into a topic that they have jurisdictional authority over. So it's not just because once you've voted on something, that matter is forever done and gone away with, right? You still maintain that jurisdictional authority over that matter. And even if it's something that you've just approved, for example, a policy, a citywide policy that this public body has now approved, it's a directive to the city manager to implement this with the department heads. So that's already done. And now we're going to talk about it. Well, that's potentially a violation, or I should say likely a violation of the open meeting law, because you still retain authority over that. That's a matter within your jurisdictional authority as this governing body. Because what you could always do in the future is you could amend that policy. And certainly there will be other provisions or aspects of that policy that will be a living document that you'll come back to examine, to address on the record. So that's something that I warn or remind my clients of from time to time, is that I understand it's been a long day. We've been in this meeting for 6.5 hours. We're all up and about, we're stretching our legs. And of course, the natural tendency of a lot of people is that, hey, we want to talk about, just sort of socially almost, as a social function. Let's talk about what just happened, what we just did. But you want to be careful. Now, I'm not saying you can't talk and you got to avoid eye contact and make a beeline for your car and get on out of there. Certainly you can speak, but you just have to be mindful about the topics you're speaking on so as not to violate that open meeting law. If it's something within your subject matter jurisdictional authority, agendize it or speak in a non-quorum setting.
Thank you, Dan. All right, we do have time for one more question, so I'll open it up to anyone if there's a question out there in Zoom land. I think someone's off Zoom, so go ahead.
Thank you, Nye County Commissioner Bruce Jabor and Tonopah.
Yeah, go ahead.
Councilor Carlton mentioned during his presentation, there was a story of a commissioner who was famous for abstaining from votes. And as we are required to take action, and by this commissioner, any other commissioner abstaining definitely reduces the quorum, especially if there's a board of 3 members versus our 5 here in Nye County. So if appropriate, are we able as fellow commissioners to challenge any of the abstentions?
For those on the Zoom, so there's a question about whether you're allowed to challenge abstentions. I don't know the answer to that, but I see Rosalie's off of mute, so.
I mean, I'm not an expert on the ethics law, but generally, abstentions are it's up to the person who is making the disclosure and abstention, whether or not the disclosure and abstention is appropriate. Because if there were to be found a violation of the ethics law, it's on the person who voted, whether or not they properly should have voted. So while you might be able to say something to them, it's ultimately up to them. No other commissioners have power over whether one abstains. When it can be difficult when you have a 3-member body, that's kind of why there was the change this time to say, if one of them is abstaining based on that ethics law, it reduces the quorum. So you now are treated as if you're a 2-member body, still needs 2 positive votes to pass something, and you could end up locked in a tie. That's where you can have difficulties. It takes some time, but anyone who is unsure whether they have to abstain can always request an advisory opinion from the Ethics Commission or seek additional advice. A recess could be taken to seek advice from counsel because they're safe harbors. But the responsibility for the disclosure and the abstentions in voting is on the person who has the conflict, and no one else has a power to change that, essentially.
Great.
Thank you, Councilor. I would just add that in this particular scenario, the commissioner didn't want to vote on controversial items, didn't want his name on the record. And so that's not fulfilling the abstention requirement, which is, as Rosalie pointed out, has to do with an ethical conflict of interest. There was no conflict of interest. This was just trying to avoid being accountable to the public. So I think in that circumstance, it would be appropriate for the other board members to ask for clarification as to why they think they have an ethical conflict that justifies an abstention. And then maybe we get them to rethink whether they really should be abstaining or not.
I'll pipe back in there. I agree with everything you just said. And I will say also that it sometimes has helped in advice I've given during meetings when there's somebody wanting to abstain, but they're abstaining because they're saying, I don't have enough information, or something that is not an ethical conflict. An abstention that is not an ethical conflict is effectively a no vote. And if it's put in those terms, sometimes people will then understand that they are effectively voting, whether or not, because action requires a majority of votes yes. So if you are not a yes vote, you are a no vote for purposes of any particular motion, unless it's that ethical abstention. And sometimes explaining that on the record, so it is clear that this person who is choosing to abstain for a non-ethical reason is effectively voting no, can encourage them to make an active vote of a yes or a no.
Thank you.
And,
Go ahead.
yeah, no, I would agree with what Rosalie just said. I mean, I think that's a good clarification there. You know, I have encountered situations in the past where I might have had a member of a committee who, based on a personal, you know, philosophy, personal stance on something. You know, for example, if there's a vote on whether or not to allow a cannabis facility or something related to a cannabis facility in Carson City. It might be, a special use permit or something like that, that's regulatory. And a member might say, I don't personally have an ethical conflict, under 281A. There's nothing that would prevent me from casting a vote, but I would rather abstain on this matter. And it's not because I don't have enough information on which to base my vote. It's because that, personally, I don't like marijuana and I don't want anything to do with it. And I don't want to vote in favor of it. And I don't want to vote against it because maybe I think there's no reason for me to vote against it if it checks all the boxes for, again, using my example in SUP. In those instances, I don't think it's, I don't think the onus is on, his or her fellow board members to say, hey, that's an improper abstention. I think that's where the onus falls on legal counsel to chime in and say, hey, that's, under, your position as an elected or an appointed official, you're encouraged to cast a vote. And just as Rosalie said, if in lieu of voting for or against, you want to abstain, really what that means, and you want to explain this on the record, that should be deemed as, or you should clarify as the member himself or herself, what I'm doing is I'm casting a no vote. And that's easy to sort of clarify on the record and explain that to your clients. So there's no confusion and there's no ongoing sort of approach to just, hey, whenever I encounter an agenda item that I'm not fully comfortable with, I'm just going to abstain. And that's not good for purposes of fostering that type of civic engagement and fulfilling your duties and obligations as an elected or appointed official.
Thanks, Dan. I missed a question in the chat, and so I'm sorry if we are running over. Hopefully there's a very quick answer to this. County manager from my county, Tim Sutton, had a question around appropriateness of items on a consent agenda. I think maybe that's, I don't know if there's anything in law that anyone could point to where there are directions regarding that. I think we recently did a consent agenda here at NACO for the first time, at least since I've been here. And the way that I sort of couched all of those items, because there were some questions from board members about that, because it was new for us, was that it was sort of moot because the board, if anyone requested for an item to be pulled off the consent agenda, that was honored. But I'll leave it to our panelists to maybe answer that question a little briefly, and then we'll wrap up the panel here.
I can speak to the law on it. With respect to it, there's a provision in the OML that that notice is required to be on your agenda, that items may be taken out of order or combined for consideration at any time. I'm sure you're all familiar with seeing that on your agendas. That's essentially your permission for a consent agenda. Every item on the consent agenda must still comply with the clear and complete standard and any other agenda requirements before possible action. But other than that, as far as the law is concerned, the use of a consent agenda is an organizational tool. And we have had complaints about things being placed on the consent agenda that people felt were improper or not placed, or the procedures of a body were such that to remove something from a consent agenda, it required a vote of the body to remove it. Otherwise, they weren't going to discuss it. That all falls outside of the OML. So as far as the law is concerned, the body's permitted to address it however they like. The most common way is there might be things listed as consent agenda, and the chair first asks if anybody wants to pull anything. If anybody wants to pull anything, it's automatically pulled for discussion, and then everything else is taken in block vote. But it's permitted specifically under the law. The actual logistics really are up to the body.
Thank you so much for that clarification. All right, I'll echo the comments from Commissioner Strickland that this was a great panel, a really great refresher for a lot of folks. I know part of the reason why NACO chose this topic is because there have been some changes over sort of multiple legislative years. Really appreciate all of the presenters again for your time and commitment today. I thank everyone's support of NACO and your attendance at this workshop. Just again, a reminder, it is recorded and will be up on the NACO website later on today. So thank you all and have a lovely weekend. Thank you so much.